All right, looks like I'm live. If you're here already, thanks for joining me. I'll give it a few minutes here to give a few more people a chance to get on. I wasn't actually planning to do a live video tonight, though usually I do them on Mondays, but I've just been so busy lately. But everything coming out this weekend and today regarding some of this ATF tyranny that's going on, I feel there's so many questions floating around. Not that I have all the answers, but I do have some of the answers if you're worried about what's going to happen in this situation. And I think a lot of it goes back to basic constitutional law. But again, while I'm waiting for some people to show up here who might be interested in this issue, and what this is, although I can't really say try not to use, you can't use election or the word gun in anything on YouTube now because you get censored or the video gets outright removed. But what this is a gun rights issue. The ATF has now raided this firearms business in Nevada called Polymer 80. And what they did is they sold a so-called buy, build, shoot kit, which is a kit that's 80% there as far as being able to make your own pistol, make your own firearm. And you could buy the kit from them, and it's not a firearm yet. It's separate pieces, all of which are legal to own. And then you have the option, once you have them, of building your own firearm, which, according to our history here in America, we have a long history of building our own firearms. And a lot of people I know build their own firearms constantly. Now, a lot of the flintlock world, the muzzleloading world, I mean, these people are constantly building their own guns. And I have a few kit guns, muzzleloading guns, but why not build your own semi-automatic pistol as well? And this is building for your own personal use, not building to sell, in which case you could do that, but you'd need to have the proper federal licenses. All right, so this is the website of the company that got raided. And the company is called Polymer 80, P80, and this is the actual product on their website that the ATF raided them about. And as you can see, it's called the buy, build, shoot kit. And this is exactly what you get in the kit right here. So it still takes about 20% of 20% more work to turn this thing into a functioning pistol. But this is the product description. Contains all the necessary components to build a complete PF940C or PF94V2 pistol. Includes the 80% pistol frame kit, 9mm complete slide assembly, and these other parts, 15 or 17 round magazine, black carrying case. So that's the actual kit. Now for years, the ATF, let's see, where am I? This is a departure, and I think we're going to see more of this now that it looks like there's going to be a Biden administration, that the ATF has really gotten emboldened, and they've started to come after a few different things that they weren't traditionally coming after. And that's these parts kits, apparently, and also pistol braces on AR-15 style rifles. But it's a departure from their old regulations, because they used to be that as long as the frame was no more than 80% complete, the ATF wouldn't consider it a firearm and it would not need a serial number. So now they've apparently changed their position to where they are taking the position that P80 is selling firearms which should be serialized over the internet to people, possibly prohibited persons. So that is sort of the reason that they used to go in and raid this place. And it comes upon the heels of allegations that allegedly some of these so-called ghost guns, and that's what the anti-gunners and the government calls them, so-called ghost guns, because they don't have serial numbers. They've alleged they've been used in several crimes around the country by people who aren't allowed to possess firearms legally anyways. So herein lies the problem that I'm talking about, is that they have apparently obtained the purchase or sale records of these kits to see who they were sold to around the country. And now, apparently, according to eyewitnesses, they're actually contacting people or showing up at the door of customers who have bought these kits and saying, do you have it? Can we see it? If you don't allow us, we'll come back with a warrant. And so now people are scared. What do they do? Is it illegal to have these kits? And if the ATF shows up at their door, should they talk to them? Or if they don't talk to them, can the ATF get a warrant and raid their house and destroy their house, knock down their door? And those are perfectly legitimate questions that people have at this point. And hopefully the audio and the video is holding up. One of the reasons I wasn't going to do a video is because I'm in West Virginia and we have ghetto internet, and it's raining today. And it seems like when it's snowing or it's raining, my connection is awful. All right, so here's the big danger. And I'm not going to go into the details of whether Polymer 80 violated any of the ATF rules as far as what firearms manufacturers or sellers are allowed to do or not allowed to do. And what I'm really concentrating on is for the people that have purchased these kits, believing that they were legal, and with the ATF taking the position that they were legal when they bought them, that now the ATF has apparently switched positions on that. What potential liabilities do they have, and what should they do? And while I don't, and I don't have the answers to any specific fact scenario, I do have the answers as far as what constitutional rights are at play here and what people need to know about. So it all is going to come down to just basic Fourth Amendment constitutional law. If you don't know better, it's always better to keep your mouth shut. It always is. It's always best to have a lawyer to ask, a lawyer to speak to that's in your state that is knowledgeable on criminal defense issues, and in particular, Fourth Amendment searches and seizures, and preferably gun rights and some sort of knowledge regarding these things. So for any specific situation, whatever the specific situation that you're in, you don't want to rely on any YouTube video or what anybody says over the internet. You want to get a lawyer and talk to that lawyer about your actual fact scenario. But you don't always have access to a lawyer when you need it. It's kind of like lawyers are kind of like the police. When seconds count, they're only minutes away. Well, lawyers, except they're probably hours away. So you always need to know anyways what your basic rights are. So just because it's the federal government involved, it doesn't mean that they don't need a warrant or that Fourth Amendment rights don't apply. So make sure that you understand what your Fourth Amendment rights are. So if the presumption is at this point that they have these customer records and they could go just door to door for anyone that they can identify as ever having been in possession of one of these kits. And how would they know where to go? Well, if you paid online, you presumably used a credit card. And if you don't think that the federal government can go to the credit card companies and get your address, your real information, whether or not you gave it to Polymer 80 or whether or not they were retaining that information, certainly the credit card companies have retained that information. So it's not a big stretch to see that they're going to be able to figure out who owned these things. Not that there was anything wrong with it, but now the reports are that they're going to the customers, going to the purchasers, and there's a number of problems there, because say the ATF or the FBI, whatever, they show up on your door, they knock on your door. They ask you, do you have this item? What do you say? What do you say if you don't have it? What do you say if you do have it? And here's the problem with that is because when you're dealing with the federal government, there is a federal statute that says you can't lie to an FBI agent or to an ATF agent. In fact, it's hard to believe that there's still people that really don't know this, but what is it? Section 1001 of Title 18 of the U.S. Code makes it a federal crime to knowingly and willfully make a materially false, fictitious, or fraudulent statement in any manner within the jurisdiction of the executive, legislative, or judicial branch of the United States. So you must, the basic requirements are, and think General Flynn, think Martha Stewart. That's exactly what happened to these people. Is they were prosecuted and convicted under Section 1001, not for the underlying crime which was being investigated or alleged crime, but for allegedly lying to federal agents. And it doesn't even have to necessarily be a lie. So when the government gets to decide what's the truth and what's not the truth, then it's on you to defend yourself. So there's a big difference in answering questions when there's a state or local police officer asking you something and the federal government. Now, sometimes it is a criminal violation to lie to a state or local cop, depending on what state you're in. In West Virginia, it's generally not illegal to lie to a police officer, but it can be under certain circumstances. It can be if they're investigating a felony crime and they tell you why they need to know something and you then lie to them. Could be obstruction. Sometimes can be, if you lie about your name under certain circumstances, it can be, for instance, obstruction. But again, those are generally misdemeanors. In federal law, when the FBI is interviewing somebody or the ATF is interviewing somebody, we have this Section 1001 of Title 18 that makes it a federal felony. And again, that's what they sent Martha Stewart to the federal prison not far away from where I'm sitting right now for lying. And look at General Flynn. He didn't even lie, according to the FBI's own notes. And they still got him because they wanted to. So generally with the federal criminal statute, you must know that what you're saying is a lie to make you guilty of this crime. But, how is that determined? You don't want to find out. So you do not need to know that you're lying. You do not need to know that lying to the government is a crime, and you're not entitled to a warning that you could be charged with a crime for lying. Now, under the federal law, the lie must be material, which means it has to be about something important, something that's not immaterial. Again, what is that? Well, you don't really want to find out or be a test case for that. So as long as a lie is related to a matter within the jurisdiction of a federal government agency, which what doesn't that apply to? The statement doesn't even need to be made directly to a federal employee. So there's 5,000 plus federal criminal statutes, federal felonies, and no one person can even know them all. So it's always better to be safe than sorry. So if there's ever a question in your mind, you should always politely ask to speak to a lawyer or to have a lawyer with you before any questioning, which of course is the same thing as saying, slamming the door in their face. So that's the real concern here, is if the feds come to your door to ask about this thing. Well, is just possessing at this point, is that a crime? Well, we don't even really know yet. I didn't see where the ATF has even issued a press release yet on this. And they love to issue press releases, as does every federal agency. And I didn't see where they'd issued one yet. So it's still in an investigation stage. So is it a crime to possess it? I don't know, but it doesn't matter. It doesn't matter. The bigger question comes first, and that's, well, whether you talk to them or not, because then you don't even get to whether the item itself is a crime to possess. And that's where it becomes important, because what happens if, say, the feds come to somebody's door and this person according to the financial records, according to the credit card company and the records on with Polymer 80, this person had bought one of these kits, and that's all they know. That's all they know. They don't know what happened to it after it was shipped to this address. So they come to the door, and the person answers the door. They say, "We're here from the ATF and the FBI, and we just want to ask you a few questions. Did you order one of these Polymer 80 kits from their website?" And at that point, say the person cuts off the contact and says, "Well, I think I'd rather have a lawyer with me before I answer any of these questions, with all due respect," or something like that. Or they cut off the conversation, they shut the door. At that point, the worry is, and I believe that these threats have been made, well, if you don't talk to us, if you don't answer our questions, if you don't let us in, we're just going to go get a warrant. And then we can knock down your door and, look through all your stuff. And it's going to go worse for you if that happens. Whether those threats were made or not, I don't know. But according to some witnesses, things like that have been said so far already in this case. So here's the question. Is that true? Because the cops are allowed to lie to you. You know that, right? There are court decisions out there actually holding that the police are allowed to lie to you. So they can say, yeah, your buddy down the street, we just had a long conversation with him, and he said that you still have it, and he said that you did all these illegal things with it. And that might not be true at all. They didn't even talk to the buddy, but it's being used as a psychological tool to scare you into talking to them. I mean, police are allowed to do things like that. They're allowed to lie to you. But so even if they lie to you or they don't lie to you, if all they know is that you had purchased this item, which undisputedly was, according to the ATF opinions or regulations or interpretations at the time, was absolutely legal, L-E-G-A-L, legal, that's undisputed. It's undisputed that they've taken a different policy here. So that's undisputed. All they know is that you bought something that was legal to buy. So if you won't talk to them, what are they going to do? Are they going to go get a warrant? That's the question. Now, what's required to get a warrant? Why do they need a warrant? Well, Fourth Amendment says that there will be no police going into your house without a warrant. That's actually what the Fourth Amendment says. So what is required to get a warrant? Well, probable cause. So a man's home is his castle. That's the maxim under our law and the English common law that we inherited. And there's no more protected place in our law than your home. So there's no doubt about it that they can't enter your house without a warrant or without an applicable exception. So sometimes the exceptions can swallow the rule. So that's why they tried first consent, for you to invite them into your house. Then they don't need a warrant. They just need your consent. Another one that I've seen people worried about here is maybe plain view. So can they come up and even look in your windows, things like that? No, there's a fairly recent case, I think is Florida versus Jardines. Yeah, that says 2013, well, not fairly recent, 2013 case says that even, around your house, the area immediately around your house, that's basically like being in your house. So they can't take a drug dog on your front porch, and that was that case, and then use that as a way around the warrant requirement. Same thing with coming up and looking in your windows. So they'd have to have a warrant to come up and do that first. But any search of a home, any entry into the home without a warrant is by law presumptively illegal. The way around that is they have to get a warrant if you don't allow them in, and that requires probable cause. So what is probable cause? Let's see. Looking for the actual language I have here. All right. Probable cause is determined by the totality of the circumstances, and a magistrate is to make a practical common sense decision whether, given all the circumstances set forth in the affidavit, that there's a fair probability that contraband or evidence of a crime will be found in a particular place. That's from Illinois versus Gates, U.S. Supreme Court, back from 1983. So what does that mean? And that's going to be the law pretty much anywhere in the United States. There has to be reason to believe that there's going to be, what does it say? Contraband or evidence of a crime found inside your house. So evidence of a crime, if they just have the sale record, what is evidence? Is there any evidence of a crime? You just buying it. Well, I don't think there could be any evidence of a crime just for that. So what about contraband? Contraband just means something that's illegal. Generally, they're talking about drugs, but it could be guns. And the possession of guns, say if that's the change in the ATF regulation is just, well, before, yeah, the 80% kits, all those things were all legal until you complete the milling to make it a firearm. But since you put all those things in one kit, it just sort of crosses that line, and we believe now that you're selling somebody a firearm. All right, so let's say they're correct about that, and the courts will agree with that this kit, this 80% kit, this buy build kit, is a firearm now under federal law. So there's a firearm in that house, even assuming all that's true. And is that contraband? There's a firearm in the house. Well, without more, I still don't think that they have enough for probable cause for a warrant, because in Nevada and in West Virginia, it's absolutely legal for without more information to have a firearm inside a home. Now, if you take somebody who is a prohibited person, and maybe that's what they're doing. Say you take the list of customers that bought the P80 kits, and you've identified everybody on that list who is a prohibited person. So all the convicted felons on that list, or it could be all the people who have a domestic violence protective order against them or have had a conviction for domestic assault or domestic battery. You take all the people on that list, and then we're going to go to their doors. And then they might be able to get a warrant against those individuals because they have the purchase record and the financial information tying the purchase to this person, to this address. And then they have the III background report that shows that this person is a convicted felon. Then they show all that to the judge, and the judge finds that there's probable cause, or judge could find that there's probable cause that there's contraband inside the house, so they get a warrant. Now that's changing the facts, because if you're just a regular customer that bought the 80% kit that was legal to buy, that were all legal items to possess, they don't necessarily have any evidence of contraband, because even if it is under ATF regulations a firearm now, it's not illegal to have a firearm. Now, there could be some gray areas and purchasing without going through an NFFL and shipping it through the mail, but those that's getting into the weeds a little bit, because in most of the court holdings are that if firearms are legal to possess, you can't impute some sort of other criminal conduct on that person just for having a firearm. For instance, in the area of law of no-knock warrants, no-knock entries, the federal courts have found that you can't just authorize a no-knock entry based on somebody being armed and dangerous just because they have a concealed weapon permit. because it's legal for this person to have a concealed weapon permit. It's legal for this person to have a firearm. And we can't, as a matter of law, impute dangerousness just by virtue of having a firearm, or at least that's the law in the Fourth Circuit. I don't recall if there was a Supreme Court case on that or not. And then you have the U.S. versus Black case here in the Fourth Circuit that says, just, in an open carry state, unless you have information that this individual open carrying is a prohibited person, that's not even reasonable suspicion to stop and ID the person. So there would have to be something more. So if they're coming to your door and they're threatening to get a warrant, the likelihood is that they don't have probable cause for a warrant, or else when they came to the door, they would have already been executing the search warrant for your house. So it's always the safest route, if you're dealing with federal agents and federal law, to go through a lawyer, go through your lawyer. If General Flynn had just gone through his lawyer, and he was dealing with a complex area of the law, we're talking about national security and conversations with foreign governments as part of a presidential transition team. Here we're talking about a complicated area of the law with ATF regulations. And you don't need to try to have a debate with the ATF on your doorstep, where anything that you say that is incorrect can land you in federal prison. It'd be better to do that, let your lawyer do that for you. So even if they have information that one is a customer of P80 and bought one of these kits that now they're deeming to be illegal to sell in this way without serial numbers and without going through the usual process, you still have your Fourth Amendment rights. So you can choose not to answer the door. You can choose not to let them in your house. You can choose not to answer questions. You can remain silent. You have the right to have a lawyer before you answer any questions, or that's another way of saying I'm not going to answer questions. So I would just point out that I don't know that anyone knows exactly where this is going, because you have an ATF that is going to see how much it can get away with. If the Biden administration is going to be in there, they're going to be emboldened. They're going to try to do more and more and more. So who knows where that's going or who they'll try to come after. Maybe they're not coming after customers. They're just looking for information to help them investigate P80, or they're just looking to see who's a prohibited person and who's not a prohibited person, and they're not going to mess with the non-prohibited persons. But if you play it safe and you ask for a lawyer, or you talk to your lawyer first, then you won't be any worse for wear. But if they are coming after you and you wouldn't necessarily know that, then you could be screwed already if you try to talk your own way out of it. Another thing I wanted to bring up is that the gun owners of America have really taken up where the NRA left off years ago and have been fighting a lot of these fights that the NRA should be fighting. And they have already taken up this issue, and I have their website around here somewhere. Let's see, because they already have a page up on this. Let me try to pull it up here. All right, this is the Gun Owners of America website, and this is the actual page they have on this issue. As ATF goes rogue, GOA calls on Trump to fire agency head. So they sort of give a rundown, and this is just gunowners.org. and you can find the link to this on their website. But they talk about the issue and why it's BS, why it's unfair. They sort of break it down, and they have a potential solution here. And it has to do with the Biden transition team. So the acting director of the ATF right now is a lady named Regina Lombardo. And she, as they said, must feel emboldened by the apparent victory by presidential candidate Joe Biden. And in November, she even began working with the Biden transition team. These were her priorities: pistol braces and 80% receivers. So even more than cooperating with the transition team, Lombardo has begun advancing the Biden-Harris gun control agenda during the Trump administration. So here's their first suggestion: is take action and tell President Trump to fire acting director of the ATF, Regina Lombardo, and her anti-gun subordinates responsible for this anti-Second Amendment attack on homemade firearms. These anti-gunners have got to go. And you can also call the White House, and they have the number right here, 202-456-1414. So while Trump is still in there, he can get rid of this lady, or at least transfer her to some other place where she can't wreak this sort of havoc, what's happening right now. So that's one thing you can do. Here is also on this website, here is the form that you can fill out to remove the anti-gun ATF directors. You just put in your name. Of course, maybe you put that in and they end up showing up at your house. So if you didn't buy one of these kits, then go ahead and put your name in here and encourage the Trump administration to do something really great on the way out, get rid of this lady. So that's one thing you can do. And GOA also, they've been very active in putting lawyers on a lot of these issues. So I suspect that they might play a part in putting together some sort of legal action against the ATF to try to resolve this tricky situation that many now find themselves in. Because what do you do? I mean, you can always contact a lawyer, and I think it's always best to work through a lawyer. But it's not going to be enough to just have, separate lawyers representing all of these people, and not all of them are going to be able to afford lawyers. So there's going to have to be some industry-wide effort by the GOA or by the NRA or by other groups to file something to get some sort of resolution here, whether by class action lawsuit or getting the Trump administration to help. There's going to have to be a broader effort, broader defense to this thing. But this is absolutely, this is a precursor to what they could be doing with a lot of other things. Really, this is a preview of coming attractions of the ATF creating new regulations, new restrictions out of thin air, just by saying, oh yeah, well, we were wrong back then, but we take a different position now. And then going to these companies and getting the sale records, and then going to anyone on that list that they want to go to. And that's a scary proposition, given the fact that it's a federal felony to give any sort of false information to these people when they question you. So always remember, the Fourth Amendment protects you in your home. Your home is your castle. You don't have to let anybody in. You don't have to consent to any searches. You don't have to answer any questions, especially when you don't know whether even possessing this item is a crime. And you don't. And nobody does. I mean, your lawyer doesn't know just yet. Now, it shouldn't be. It can't be. But it also could be. And do you have a whole lot of faith in allowing a court to decide your fate on that issue? No. Play it safe. And go to a lawyer. Always, always, always speak to the feds through your lawyer. Let your lawyer do it. You don't have to let anybody in your house. And if you were a customer of one of these these kits, You might want to be proactive and reach out to your lawyer and have somebody on standby to begin with, because maybe they're going down these lists and they're showing up at people's houses, or maybe they're not. But in the end, it's all going to come down to basic constitutional law, basic Fourth Amendment stuff. Come back with a warrant. A warrant requires probable cause. And at least in West Virginia, and I suspect in other states, because this is going to be based on DOJ policy, it's actually more difficult for federal agents to get search warrants in West Virginia than it is for local cops. See, the DEA had done a lot of this stuff, even here in West Virginia, where when they were going after all the overprescribing doctors, they were raiding a doctor's office or a dentist office in broad daylight during business hours, and then they were getting all of the records. Then they'd use that and go from there, or they'd go to the next doctor's office. Now, the DOJ regulations were requiring that they get a warrant from an actual circuit court judge. Now, in West Virginia, usually it's the magistrates who issue warrants, and under state law, the magistrates are qualified to issue the warrants. The problem is that most of the magistrates in West Virginia, like some other rural states, are not actually lawyers. They have no law degree. They're just somebody who ran for it, and they may have some training after they got elected, or they may be, in many cases, former cops. So the DOJ, and this is telling, because there's people sitting in jail across the state on warrants issued by magistrates, but the Department of Justice will not allow their federal agents to obtain a warrant from a magistrate. They make law enforcement contact the circuit court judge. Far as I know, last I've heard, the circuit court judge to actually sign the search warrant when they're getting their federal, not their federal because it's a state, but when they're executing state warrants for investigations of violation of federal law. So, that might make it even more difficult for them to obtain a warrant. So there still has, probable cause is always going to require evidence that there was some illegal conduct. And, when it comes to firearms, if firearms possession itself is legal and you're not a prohibited person, that's going to be difficult to do. So it's going to be a high standard for them to make to come raid somebody's home just based on the purchase record. And that's probably why you see them knocking on the doors and asking questions. And remember, they're taught that in all these police academies that consensual contact is always allowed. So the so-called knock and talk, where they knock on the door and they ask you questions. The case law, the federal case law, holds that just like anybody can do that, they can do that. If you're dumb enough to answer the door and sit there and answer all their questions, they don't have to have a warrant. They don't even have to have an exception to the warrant, because that's consensual, supposedly. That's consensual contact. That's a knock and talk. When they're doing these things, they're trying to build up evidence for probable cause to get a search warrant. If they already had probable cause, they'd already be searching your house. You'd already be in handcuffs generally, and they'd already have a search warrant. That's what they need, is evidence to substantiate probable cause for a search warrant. And that's going to be your answers, your responses to their questions. Do you have this item inside your house right now? Did you finish that kit? Or what did you do with it? So they're always going to use your answers to these things. Or, have you ever been convicted of a felony or a domestic assault or battery charge? It could always be, of course, any conviction that, they'd be able to look up, they'd already know. But there could be other things that could make you a prohibited person. And, there's no point in giving them that evidence from your own mouth. Okay. Bill, Montana puts a high value on privacy. It's a high standard to establish probable cause and execute warrants. Well, states are always free to grant higher, well, strike that. States can always protect their citizens under state law greater than federal law. They can't lower the standards. So yeah, state could make a probable cause standard higher, but they could never make it lower than as established by the federal case law. And that's a good thing. Montana is a beautiful state. That's where my family's actually from. I converted my ghost gun into a squirt gun. Thank you and have a nice day, Mr. Agent. Well, Semper Fi, they already got you right there, because then all they have to say is that you didn't convert it into a squirt gun. And boom, they got you in federal prison right there. That's a lie to a federal agent about a material item regarding their investigation of these federal crimes. Suspicion is not probable cause. That's right. There are two things which are often confused, and that's reasonable suspicion and probable cause. Now, reasonable suspicion is what police need to detain you, to make a traffic stop, to ask ask for your ID, and that's an investigatory detention. So reasonable suspicion is a much lower standard than probable cause. But reasonable suspicion still requires suspicion of criminal conduct. And if it's just possessing something that was legal to possess or is legal to possess, that can't even be reasonable suspicion, much less probable cause. So probable cause is supposed to be a much higher standard. And also, while we're talking about warrants, somebody had asked me, well, what if if I don't cooperate, then they go get a warrant, then they come knock down my door and they trash my house. So best case scenario, they've completely trashed my house. Can I sue them? Well, if they're federal agents, there's a problem anyways. But even putting that aside, once a search warrant has been obtained, or it could be an arrest warrant, it's very difficult to file a lawsuit at that point, because there's a presumption in the law that the warrant is valid. Therefore, to sue for civil rights violations after the execution of a warrant, you have to go inside that warrant and you can make what's called a Frank's claim. You have to prove that the officer lied to get that warrant, or gave just really materially false information that they should have known what was false, and that information persuaded the judge to issue the warrant, and what wouldn't have otherwise been issued. So those are very difficult cases to make. And usually, for instance, with an arrest warrant, if a police officer arrests somebody pursuant to an arrest warrant, then you can't just say, well, that's a wrongful arrest. There was no probable cause. Here's how I can prove there's no probable cause. I was absolutely innocent. The actual law on that is like, no, that's irrelevant. Because there was an arrest warrant, the police officers who arrested you were reasonable in relying on that arrest warrant as a matter of law. The only way that you can attack that arrest is to prove that it was an illegal warrant that was obtained by fraud, by lying, and that it wouldn't have been granted otherwise. It can be done, but it's not easy. But instead of just showing there's no probable cause, and if you have a warrantless arrest, that's much more simple. You just, you have to have probable cause to arrest somebody without a warrant. And if you can prove that there was not probable cause, then it's an unlawful arrest. That's a much easier case than trying to prove that there was a lie used to obtain the warrant, and that the warrant never should have been issued but for that law. And it's very difficult, and I've done it, but it's very, very difficult. So once they have a warrant, it's very difficult to sue, is the point. Now, if you talk about federal officers, federal agents getting a warrant, then it's very difficult, because you can't sue federal employees under Section 1983 like you would file a regular civil rights lawsuit. You have to sue them under what's called a Bivens claim, and that's a U.S. Supreme Court case that outlines the process of, yeah, you can sue federal police officers, but you have to do it under this Bivens thing. And it's no real different as far as proving the case, but in practicality, here's the difference. Instead of having an insurance policy and an insurance company defending and being able to settle a good case, when you're suing a ATF agent or a FBI agent or a DEA agent or a U.S. Marshal, it's, instead of the insurance defense lawyer you're dealing with, it's being defended by Assistant United States Attorney, basically a federal prosecutor, just in a civil case. And guess what? They don't settle the cases. They don't settle them. They just take them to trial, or they don't take them to trial. And if you win, they throw the officer under the bus. It's his or her debt. Too bad. The government's not paying for it. So they defend them, but they don't indemnify them from awards. So while that might be the more just way of doing it, it's going to be harder to find a lawyer to finance that case for you, because there's no insurance policy on the hook. And you're not going to want to depend on anybody's personal assets, because they could file for bankruptcy, or they could have gotten rid of them, or they may not have had them. So it's a much more difficult task of going after or holding accountable the federal police officers who violate civil rights. Now, the one good thing there is there's a huge and multiple mechanisms for internal review in the Department of Justice that you don't have in state agencies. So if you make a complaint, for instance, to the Civil Rights Division of the DOJ, you make a complaint to them, and there's a criminal division, and then there's the special litigation section, where I worked at one time. They handle the pattern or practice allegations, and then the criminal division handles the actual, specific instances of criminal conduct. And that could be by a state or local police officer, or it could be by an FBI agent. So they will investigate their own. No doubt about it, there are places you can make a complaint where there will be, in most cases, an unbiased and thorough review of allegations of misconduct. But the route of being able to get justice through money damages, through filing of a civil lawsuit, it's very, very difficult. And there are other ways of attacking warrants. Even if there is a warrant, even if you can't challenge the warrant, you could challenge the execution of the warrant. So if the warrant said that they could look for computer files, for instance, that's a bad example, because it could go the other way. All right, so if the warrant says that they're looking for a car, all right, yeah, they're looking for a car. So the car could be in the garage. They can look in the garage. But if you can't fit a car anywhere else in the house, then arguably, depending on how the warrant's written, that could be a civil rights violation, a Fourth Amendment violation of exceeding the warrant by going through the bedroom drawers and looking in the closet and looking under the bathroom sink, because the search warrant said they could look for this stolen car. And really, it could only be in the garage or in the workshop behind the house. So if you can prove that they went beyond the warrant, or they exceeded the warrant throughout the performance of the warrant in some way, or the execution of the warrant, then you could have a claim. For instance, I've used this before with entry cases, with knock and announce, with no knock entries. If the warrant doesn't say that you can you can dispense with a knock and announce requirement, and they perform a no knock entry and bust down the door before they even announce their presence, and they can't substantiate that with some sufficient reason of why they didn't knock and announce, then maybe they exceeded the scope of the warrant that they were authorized to execute. And that's just a knock and announce requirement violation. And those can be done as well. But the point is there's not a whole lot of good options if they do get a warrant to try to seek justice. The best thing always to do is to know your rights before it even gets to that point. So they can always knock on your door and ask you questions so long as you want to answer them. But you have a right not to do so. You have a right to have a lawyer. And I think the facts of the situation are, at this point, with allegations that they have approached people at their house and threatened to come toss their house with a search warrant, I think the allegations are sufficient enough to make it very reasonable to say, look, I'm happy to talk. I want my lawyer first, though. Excuse me, losing my voice here. Just looking at some of the questions here. Go-Fis, separate warrants for home and car. Well, a search warrant is a search warrant, and you could have separate warrants for a house and a car, but you could have a warrant for a house that also includes a car. And that's a good question. That'd be a good question for the lawyer that you contact, because there could be cases that are different depending on what state you're in or what circuit you're in. But the one common theme you'll see when you look through all of these Fourth Amendment cases is that the phrase totality of the circumstances. So they're all highly fact dependent. So whether or not there needs to be a separate warrant for the house or the car, it's for sure is going to depend on the facts of the case, of exactly what the warrant said, what they were looking for, where the car was. I'm pretty sure I just answered that question. Assuming a valid warrant, can you sue for damages caused by executing the arrest? So yes, you can sue, but you're forced to go through this, at least with federal civil rights law, you're forced to go through this, quote, Franks claim. And that's what Franks versus Delaware, or Delaware versus Franks, is a U.S. Supreme Court case. And there might be a mechanism for reimbursement for actual physical damages during some of those situations as well. But that wouldn't be a Fourth Amendment claim in and of itself. All right, they get someone else to give them your information without your consent. So generally, there are legal mechanisms out there where you can lose your civil rights thanks to a third party. That can happen all the time. For instance, the cops come to the door and say, "Can we come in?" And the guy answers the door. They don't know who it is. And the person is acting consistent with being somebody who lives in the house. And then the question, it turns out that it was just some dude who was visiting. Is that sufficient consent to enter the premises? And it's usually an objective reasonableness standard. And yeah, it happens all the time. So third party, whether or not you consented or not, that's between you and that company, or you and that third party. The federal government doesn't have to get your consent to have gotten your customer information, for instance, from Polymer 80. I mean, according to federal constitutional law, there might be some state law in Nevada or some other state that has some sort of privacy protections. And there is actually a claim called violation of privacy under federal law. And I tried to make that claim, and it's a very weak claim. It's very difficult to make. It might work for medical records. Probably mental health records is really where I think a lot of the case law comes from. But gun buying records, gun parts buying records, I don't think they're going to apply that, unfortunately. All right, Matt, look at Joseph Rowe versus ATF. ATF had to drop the case because ATF's definition of a firearm does not accurately describe a lower or upper receiver. And that's why I'm saying that it's do you want to try to debate these issues on the site with the ATF? No, I mean, leave it up to your lawyer to do that in court or outside your presence, really, because some of those issues could be difficult, or the laws can change. And look at Joseph Rowe. I mean, what happened to him that his name is now on this case? Okay. Can cops force the occupants of a house to leave if they're not subjects of the arrest warrant? Yeah, sure they could. I mean, usually the question is can they put the occupants of the house, even if they're not suspected of having committed any crime, in handcuffs? And unfortunately, yes, according to the U.S. Supreme Court and a lot of lower court decisions, law enforcement can handcuff the occupants of a house, whether or not they've done anything wrong. They could just be visitors for the duration of the search. And there could be a violation if they keep them handcuffed for too long. But some of the terrorism cases is where a lot of this case law came from. And I mean, the courts have upheld hours before. My ghost gun only fires Bible verses. Prohibited persons is an oxymoron. Yeah, it is. That's the actual legal term that they use, though. But it is a ridiculous term. Would it not be nice if West Virginia law required a warrant to issue a lawful warrant? Required a warrant to issue a lawful warrant like regular states? I take it you're referring to the warrants issued by magistrates. Yeah, I think it's interesting that the federal government will not allow law enforcement, even state and local law enforcement, to get a magistrate warrant. Yet the state prisons are populated with people who wouldn't be there but for a magistrate warrant. I mean, either it's legal or it's not legal. All right, Fred Johnson, no warrant, can tell them they're trespassing if they don't leave. There's no doubt that if law enforcement comes to your door, that you can ask them to leave. And, you can turn on your GoPro first and film the whole thing and then put it on YouTube. And there are people who have done that. And that's not a bad idea. I mean, if you know that they're going to be coming to your door, film the whole thing. Film the whole thing. Because then that will I mean, you can't argue with the video evidence. I mean, they can always say that you said something that you didn't. But if there's a video of it, yeah, there's always some risk in even talking at all, just to say, no, thanks, I wouldn't like to talk, and close the door. So yeah, it could be a scary situation to be in. So if you're one of these customers, the point is be proactive about it. You need to find legal counsel that you're going to rely on if you can afford it. If you can find somebody that you at least feel comfortable with their criminal defense credentials. And whether or not they're going to be educated on this issue or not, they can always educate themselves on this issue. And it remains to be seen where this is going to go, what the ATF is going to do. But it all comes down to basic Fourth Amendment law, and that is that they're not entering your house without a warrant. And they're not arresting you at your house without a warrant. They're not searching your house without a warrant. And you always have a right to keep your mouth shut. And you can do so politely or impolitely, but I would recommend politely and put your lawyer on it. And I think it would be a huge shock if one were to do that and they still found some way to charge people criminally just for having purchased these items. I think that they're looking for the low-hanging fruit. They're looking for the so-called prohibited persons, or they're looking for people that will just run their mouth and answer all their questions. And then they can, even if it's not illegal, what they've done, they can just get them on a process crime, just like they did General Flynn. So I'm just catching up on this issue as I have time to, just like everybody else. But it's just kind of shocking news that the ATF is first they're coming after pistol braces, but now they're coming after these part kits. So if you know anybody that has purchased these kits, or you've purchased them yourself, just make sure you know what your rights are, and you probably want to communicate with I think the Gun Owners of America or the NRA, whoever's going to be taking on this issue. And there's going to need to be some sort of collective fight against this. So that's about all the time I have. Hopefully the video held up, even though it's raining outside. And I might do another video on this after I see where this is going. And if you need to get a hold of me, you can find me at thecivilrightslawyer.com. And until then, I appreciate it. Thanks for watching. Make sure to subscribe on YouTube. I'm also on Facebook. The blog website where I do all my writing is at thecivilrightslawyer.com. We also have a lot of other interesting cases going on right now, and some more coming up really soon. So until then, I'll talk to you next time.